just like the Debt Commission told us. Don't we know that? I thought that was what the past election was last fall, when the big spenders and the high-tax guys got shellacked. I thought Congress would get the message. Apparently we haven't. The debt situation we're in is not a little bitty thing. On the Congressional Budget Office analysis, we call it scoring, of President Obama's 10-year budget. Last year, we had interest on the debt that we now owe of a little over $200 billion. According to the analysis of the President's budget, in the 10th year under his plan, the Congressional Budget Office estimates that we will pay in interest in 1 year $940 billion. Now, I know that's so much money, it's difficult for people to comprehend it. Alabama is a state of just about average size. We're about 1/50th of the United States. We have a lean government that's making some serious reductions in spending because our money hasn't come in, and we have a constitutional amendment that requires the budget to be balanced. But the amount of money that Alabama spends on its general fund obligations is $1.8 billion. And under the budget that has been submitted to us by the President 2 or 3 months ago, just his proposal, Congress has to pass the budget, not the President. He submitted his proposal. It would cause the interest on our debt in 1 year to reach $940 billion. That's way above what we spend on defense. It's way above what we spend on Medicare. It's the fastest growing item in the entire spending plan of America, interest on the debt. And that's why Mr. Bernanke, Chairman of the Federal Reserve, Mr. Alan Greenspan, our former chairman, the International Monetary Fund, Moody's, the Debt Commission, have all told us this is unsustainable. You can't continue. We won't go 10 years without a debt crisis. When asked, Mr. Bowles said we could have one in 2 years, maybe a little sooner, maybe a little later. I'm not predicting that. But if we don't change, that could happen, as expert after expert has said. So I hope that somehow, some way, in the days to come, that we'll see the regular order be reestablished, that our colleagues, they say they've got a budget, they say they've certainly talked to the Democratic members on more than one occasion about it. Let's bring it forward. Let's see it. Maybe it has some good things we can agree on. It'll probably have some things that I wouldn't agree on. But it can be passed. You can't filibuster a budget. Under the Budget Act, it can be passed by a simple majority. A budget can clear the United States Senate. But you know what? If you produce a budget, you have to tell the American people what you really believe about America, where you really want this country to go. And do you want a limited government, or you want to continue to expand a larger and larger government? Do you want to raise taxes more and more to sustain spending levels higher than we've ever had them before? Is that what we want? Or are you prepared to make reductions in spending? One or the other has to occur. We cannot continue to borrow at the rate we're borrowing, as every expert has told us. So I'm challenging the leaders of this Senate who asked for the job, who asked to be leaders of the Senate, asked to be given the responsibility of helping guide our nation, to step forward and provide leadership. In the joint statement issued by Mr. Bowles and by Alan Simpson that they submitted to the Budget Committee, they said, this nation has never faced a more certain financial crisis. Actually, I'll get the word straight. The nation has never faced a more predictable financial crisis. In other words, to the experts that they heard from and who testified to them and based on their own study, they believe we're heading to a financial crisis. Alan Greenspan recently said, I think the Congress will at some point pass reform in spending and budget matters. The only question is, will they pass it before or after the debt crisis hits? So we have that challenge. We have no higher duty than to protect our people from a foreseeable danger. That danger is out there. We're heading right toward it. It's time for us to stand up and be honest and face that challenge. And I don't believe business as usual should continue, and I will object to it insofar as I'm able. I would thank the chair and yield the floor and note the absence of a quorum.
Clerk will call the roll.
Mr. Akaka.
Mr. President, I ask unanimous consent that the quorum call be vitiated.
Without objection.
Thank you, Mr. President.
Morning business is closed. Under the previous order, the Senate will resume consideration of the motion to proceed to Senate S-1038, which the clerk will report.
Motion to proceed to the consideration of S-1038, a bill to extend expiring provisions of the USA Patriot Improvement and Reauthorization Act of 2005 and so forth, and for other purposes.
I thank the clerk very much. Mr. President, as chairman of the Senate Intelligence Committee, I want to point out that as of Friday, there are 3 provisions of the Foreign Intelligence Surveillance Act which are going to expire. Those 3 provisions are something called the roving wiretaps, the lone wolf provision, and the business records authority. Now, because of prior discussions, let me point out up front that this does not include national security letters, just these 3 provisions: roving wiretaps, lone wolf, and the business records authority. I very much appreciate that the majority leader and the Republican leader have come together in agreement to bring this legislation to the Senate floor. And because of its importance, particularly at this point in time, I hope we will be able to conclude this business and see that these provisions are extended for 4 years before Friday. Many of us strongly believe when it comes to national security, there should be no partisan divide, only strong bipartisan support. And so this measure should receive a substantial vote this afternoon, and the Senate will pass it quickly this week before these key authorities expire. But before talking about the substance of the legislation, let me describe the context in which this debate occurs. 3 weeks ago, on May 1st, the United States carried out a risky, complicated, but ultimately successful strike against Osama bin Laden in Abbottabad, Pakistan. The strike was the culmination of nearly a decade-long intelligence operations to locate bin Laden. Like most complex intelligence challenges, finding bin Laden was the product of multiple intelligence sources and collection methods. It was a seamless effort led by the CIA, with important contributions from the National Security Agency, known as the NSA, and the National Geospatial Intelligence Agency as well. The intelligence mechanisms that are employed in counterterrorism operations are carefully and regularly reviewed by the Senate's Intelligence Committee. Some are also overseen by the Judiciary Committee, on which I also have the pleasure to serve. These intelligence tools include the provisions of the Foreign Intelligence Surveillance Act, or FISA, and in particular, the three provisions that will, if not reauthorized, expire on May 27th. Again, they are the roving wiretap, the lone wolf, and the business records sections. The point is, we as a nation rely on certain secret sources and methods to protect our national security, and most other nations do the same thing as well. It is also important to note that the strike against bin Laden, while a critical strategic blow to al-Qaeda, is also very likely to lead to reprisal attempts. There have been calls for attacks against the United States after the bin Laden strike from al-Qaeda in Pakistan, from al-Qaeda affiliates in Yemen and North Africa, and there is very real concern that radicalized Americans here at home may contemplate violence in response to extremist calls for retribution. So this is a time of heightened threat. Maybe no specific threats, but certainly heightened threats. And we see attacks in Pakistan carried out by the Taliban in reprisal for this attack as well. Therefore, this is a time when our vigilance must be heightened as well. Key officials from the National Counterterrorism Center, the FBI, and the Department of Homeland Security recently described to us in closed session how their respective agencies have heightened their defensive posture over just these very concerns. So clearly, this is a time where every legal counterterrorism and intelligence gathering mechanism should be available. It is also a time to seize the opportunity to further disrupt al-Qaeda. The assault on the bin Laden compound netted a cache of valuable information, papers, videos, computer drives, and other materials about al-Qaeda's vision and al-Qaeda plans. The intelligence community established an interagency task force to go through that material as quickly as possible, and I am hopeful that previously unknown terror plots will be identified and information leading to the location of terrorists found. Authorities, like the three provisions set to expire this Friday, may well prove critical to thwarting new plots and finding terrorists. They must be renewed. Let me describe the three provisions in more detail. First, the roving wiretap provisions. Roving wiretap authority was first authorized for intelligence purposes in the PATRIOT Act in 2001. But as you know, Mr. President, it has been used for years in the criminal law. This provision, codified in the Foreign Intelligence Surveillance Act, provides the government with flexibility needed to conduct electronic surveillance against elusive targets. Now let me explain. In most cases under FISA, the government can go to the Foreign Intelligence Surveillance Court, which I will describe in detail later, and present an application to tap the telephone of a suspected terrorist or spy. The FISA court reviews the application and can issue an order, basically a warrant, to allow the government to tap a phone belonging to that target. Now, we all know in this day and age there are disposable or throwaway cell phones that allow foreign intelligence agents and terrorists not only to switch numbers, but also to throw away their cell phone, to dispose of the cell phone and replace it with another. This roving wiretap authority allows the government to make a specific showing to the FISA court that the actions of a terrorist or spy may have the effect of thwarting intelligence. They make, in other words, they make one appearance. The government can thus seek, and the FISA court can authorize, a roving wiretap so that the FBI, for example, can follow the target without having to go back to the court for each cell phone change. Instead, the FBI reports to the FISA court, normally within 10 days of following the target to a new cell phone with information on the facts justifying the belief that the new phone was or is being used by the target. The Justice Department has advised Congress that the authority to conduct roving electronic surveillance under FISA has proven to be operationally useful in some 20 national security investigations annually. So this provision is both used and very necessary in this day of throwaway cell phones. Lone wolf authority allows the government to request and the FISA court to approve intelligence collection against non-United States persons who engage in international terrorism, but for whom an association with a specific international terrorist organization may not yet be known. So let me explain that more clearly. All other foreign intelligence surveillance searches and surveillances must be focused on a target who the government can prove is tied to a foreign power. So before the government can tap a phone or search a residence, it needs to demonstrate that the person it is after is an employee or spy or otherwise working for or on behalf of another country or terrorist group. The lone wolf provision, which was added to FISA in 2004, recognizes that there may be cases where the government suspects an individual inside the United States of plotting a terrorist attack, but it hasn't been able to link that individual to al-Qaeda or al-Shabaab or another group. The lone wolf authority allows the government to go to the FISA court, show why it believes a non-U.S. person is engaging in terrorist activity, and get a warrant to begin surveillance. This is not done without a warrant from the court. It also allows for court-ordered collection against a non-United States target who may have broken with a terrorist organization while continuing to prepare for an act of international terrorism. The Justice Department has advised Congress that although to date it has not used this authority, lone wolf authority nevertheless fills an important gap in United States collection capabilities, and we have it if we need it. The recent case of Khalid al-Dawsari, a Saudi national arrested in Texas this past February, shows why the lone wolf authority is necessary. Al-Dawsari was arrested after the FBI learned that he had purchased chemicals and conducted research needed to make improvised explosive devices. He had also researched bomb targets, including dams in California and the Dallas residence of former President George W. Bush. Unlike other recent terrorists, like Najibullah Zazi, David Headley, and Umar Farouk Abdulmuttalib, al-Dawsari was not identified on the basis of his connections to foreign terrorist organizations or known at the time of his capture to be working with one. He is better described as one of the most recent cases of individuals already inside the United States who becomes radicalized and committed to carrying out terrorist attacks. So it's for this kind of threat that the lone wolf authority is important, and for why we should extend this mechanism. It is also this kind of threat that the intelligence community is now especially worried about, as people inside the United States may be spurred to action in retaliation for the strike against bin Laden. If the FBI or Department of Homeland Security or a state or local police officer identifies someone building bombs, it is necessary to move quickly and not take time to research a possible connection to al-Qaeda before we use FISA authorities to learn what they're up to and when and how they might strike. Business records. The third authority covered by this legislation is known as the Business Records Provision and provides the government the same authority in national security investigations to obtain physical records that exists in an ordinary criminal case through a grand jury subpoena. Business Records Authority has been used since 2001 in FISA to obtain driver's license records, hotel records, car rental records, apartment leasing records, credit card records, among other business records. This is the way in which you track a target. Let me note that while the debate over this provision has often focused on library circulation records, the Justice Department has advised the Congress that this authority has never, and let me stress, never been used to obtain library circulation records. We had a big debate on this when this came up before, and in fact, it's never been used for library circulation records. The Department has informed Congress that it submitted 96 applications to the FISA Court for business record orders last year alone. The Justice Department has further stated that some business records orders have been used to support critically important and highly sensitive intelligence collection activities. The House and Senate Intelligence Committees have been fully briefed on that collection. Information about this sensitive collection has also been provided to the House and Senate Judiciary Committees, and information has been available for months to all senators for their review. The details on how the government uses all three of these authorities are classified, and discussion of them here would harm our ability to identify and stop terrorist attacks and espionage. But if any senators would like further detail, I encourage them to contact the Intelligence Committee or to request a briefing from the intelligence community or the Department of Justice. Now, I've mentioned several times the role of the Foreign Intelligence Surveillance Court. Now, let me describe what it is and how it operates. This court is a special court. It is a set of 11 federal judges, each of whom is appointed by the Chief Justice to specifically serve in this role. At least one of these judges is available at all time, 24/7, 365 days a year, 7 days a week, for the purpose of reviewing government applications to use FISA authorities, and if those applications are sufficient, approving them by issuing an order or what you'd call in the criminal law a warrant. The FISA court judges meet in closed session to review classified declarations, and they provide very careful judicial review of the government's applications. They are expert in this specialized area of the law, as is their expert staff. The Department of Justice officials that come before them take all care in making their case and presenting their facts as they do in public court. So the American people should understand that these FISA authorities that we are discussing now, the ability to conduct electronic surveillance and obtain records, are subject to strict oversight. A Senate-confirmed official in the Department of Justice, the Attorney General, the Deputy Attorney General, or the Assistant Attorney General for National Security, one of these three must, and I stress must, sign off on every application before it goes to the Foreign Intelligence Surveillance Court. Federal judges, also confirmed by the Senate, must improve the applications. Inspectors general conduct regular audits and oversight as well. And the Senate and House Intelligence and Judiciary Committees receive regular reports from the Department of Justice on the use of all FISA authorities, as well as receiving briefings from the FBI and NSA on the implementation of the FISA statute. The three authorities reauthorized by this legislation have been debated extensively on this floor and in this Congress since they came up for reauthorization in 2009. Every single national security official to come before the Congress in the past 2 years has testified that these provisions are vital to protect America and has urged their reauthorization. It's very hard, I think, to vote no in face of what we have been told in classified intelligence, in hearings, by officials from the Attorney General's office and the FBI. In fact, the Attorney General and the Director of National Intelligence wrote a letter to leaders Reid and McConnell today, May 23rd, expressing their strong support for the immediate enactment of the legislation we're now considering. And I ask unanimous consent, Mr. President, that this letter be inserted into the record.
Without objection.
Let me point out there are no recent cases of abuse of these authorities. No recent cases of abuse of these authorities. And the oversight system in place is working well, I believe, to ensure they will not be misused in the future. Now, other senators may come to this floor and talk about abuses of these authorities, but I ask, listen carefully. Chances are they're talking about a section not involved here, and that's the section on national security letters. Again, national security letters are not touched by these three sections that we are renewing today. And I would say yes, they were abused or misused in years past, according to the Inspector General of the Department of Justice. But corrections have been made since then. But more importantly, for today's debate, there's nothing we're taking up today that affects or mentions national security letters at all. I've referred to this now 4 times. I hope I get it across, because that's what happened last time. People came to the floor, and what they were talking about wasn't really in the legislation we were considering. Earlier this year, I was pleased to support legislation authored by Senator Leahy that would have made several improvements in the Foreign Intelligence Surveillance Act in order to better protect privacy rights and civil liberties. But the point I made during the debate in the Judiciary Committee, which I will repeat again today, is that many of these changes were in fact codifying practices the Department of Justice and the FBI have already implemented. For example, minimization. That was one of the things that was discussed. It's been implemented. So the departments are listening, and they have taken action where there have been problems. So I would like to say to my colleagues that the executive branch has heard and has acted to address concerns about intrusions into American civil liberties. The Office of the Inspector General in the Department of Justice has indicated that it intends to conduct audits and inspections to ensure that the implementation of FISA is in full compliance with the law, and its reports will be carefully reviewed by this Congress and by the concerned committees. A major priority of the Intelligence Committee in this House is to conduct regular oversight on the use of FISA authorities, and we will continue to do so after passage of this legislation. Now, just about every administration official to testify on the use of FISA authorities has also noted the importance of having the stability that comes with a long-term extension. Since December of 2009, when we reauthorized it, the Congress has passed 3 short-term extensions, one for 2 months, one for 1 year, and one for 3 months. So, by lurching from one sunset to another, we run the risk that these intelligence authorities are going to expire. And here we are once again, because they expire this Friday. And I hope members will think about that. I hope members will think, if they want to produce an amendment, look, this thing goes out of place. What if NSA and other agencies have to stop? What if they miss something? What if something happens? That's a responsibility that rests on the heads of everyone in these 2 bodies, both the House of Representatives and the Senate of the United States. Even short of that, by providing one short-term extension after another, 2 months here, a year there, we create significant uncertainty in the intelligence community as investigators aren't sure whether these tools will continue to be available to them. I can tell you, as one who tries to read the intelligence rather assiduously, we are not out of harm's way, and no one should believe that. People are plotting every day as to how they can send someone into the United States or convince someone in the United States to attack this country. And the only thing we have to prevent this from happening is intelligence, and an FBI that is now able to institute surveillance and tracking on possible targets in this country. Mr. President, we have come, in my judgment, a long way since 9/11, but we cannot leave this country vulnerable. We must keep our guard up, and we must see that the intelligence mechanisms that are available to this country are able to be utilized. So, this legislation now extends the use of these sunsetting authorities for 4 years to June 1, 2015. And in view of the time that we're living in, I believe this is appropriate, it's keeping with past practice, and it's vital to the protection of the United States of America. The PATRIOT Act was enacted in October 2001, and several provisions were up for review and reauthorization 4 years later, in December of 2005. After some significant debate, some of the original PATRIOT Act provisions were made permanent, and some were reauthorized for another 4 years until the end of 2009. The lone wolf authority that expires later this week was first enacted in the Intelligence Reform Act of 2004 and placed in the same sunset cycle as the roving wiretap and business records authorities. Under the model established in the PATRIOT Act and its subsequent reauthorization, a 4-year extension from the end of May 2011 to June 1, 2015 is based on sound congressional practice. So, these issues have been debated and redebated and should be very familiar to members, especially those on the Intelligence and Judiciary Committees. So, I hope we're now going to act in the best interests of protecting the people of this country from another terrorist attack by passing this legislation so that our intelligence professionals can continue to keep this nation secure. Thank you, Mr. President. I yield the floor.
President.
The senator from Indiana.
Mr. President, Tomorrow morning, a joint session of Congress will welcome the Prime Minister of Israel, Benjamin Netanyahu. It will be the first time that Mr. Netanyahu has addressed us as a joint session, and only the second time any Israeli Prime Minister has addressed a joint session of Congress as its sole participant. It is a distinct and historic honor and an opportunity for us to hear again how crucial is the friendship between our two countries. In anticipation of this event, I rise today to provide for the record a restatement of how I and I believe many, if not most of my colleagues, regard the state of Israel and America's relationship with that fellow democracy. This restatement is necessary, I believe, in light of the President's speech last week regarding the Arab Spring. The President's remarks, which were delivered just before Prime Minister Netanyahu's arrival in the United States, seriously muddied the waters of American policy toward Israel and its troubled region. The Arab Spring has sprung from new popular forces throughout the region, overthrowing regimes that have lost their relevance to the aspirations of their people and threatening to overthrow others. The administration's response has been slow in coming, awkward and confused in efforts to explain its policies, inconsistent in its application from one part of the region to another, less than transparent with keeping Congress informed, and worse, in the Middle East and Northern Africa have stirred justifiably the emotions and aspirations of the Palestinian people as well. They also seek a homeland of their own, secure, stable, and living at peace with its neighbors. I agree that this must be among our goals. Some believe that the groundswell of newly vibrant popular aspirations throughout the region and also among the Palestinian people is both an opportunity and a requirement for new creative steps in the search for a permanent peace. There may be an opportunity here that leads to progress if we and the parties to this long-lasting dispute make the right choices, if we seek the right ends, and if we pursue them with the right strategies. Unfortunately, Mr. President, the administration seems to misunderstand the nature of this opportunity. In a speech last week regarding the wave of startling events in the Middle East and North Africa, President Obama attempted to bring coherence and purpose to his administration's policy. Instead, the speech brought more confusion, potentially jeopardizing prospects for successful negotiations with Israel and the Palestinian Authority. Mr. President, in my opinion, it was a serious mistake for the President to preemptively declare U.S. support for a Palestinian state based on the 1967 borders. President Obama's declaration that Israel must withdraw to the 1967 border lines is unprecedented and unwelcome. It is true that previous administrations have referred to the 1967 lines in the past as a reference point in negotiations. And it is also true that the Palestinians regard the 67 lines as their beginning negotiating position. But even with the President's vague acknowledgement of the need for land swaps, no U.S. administration has previously adopted the Palestinian position as its official policy until now. How can this help restart negotiations or drive those negotiations toward a successful conclusion? As Mr. Netanyahu made clear to the President in the Oval Office, a return to the 1967 lines is indefensible and ignores new realities on the ground. This position was formally recognized by President Bush in 2004 and must now be reconfirmed by any realistic assessment of what steps are possible and necessary. The object of negotiations is to reach a successful and durable conclusion. But ignoring core realities cannot possibly contribute to progress and almost certainly would make it more difficult to achieve the ends that we all seek. Another major concern I have following the President's speech is the reaction to the recent announcement by the Palestinians of a reconciliation agreement between the Fatah party of President Abbas and Hamas, the organization in charge in Gaza. The alleged reconciliation is likely a product of the Arab Spring and the conviction that the Palestinians need to unite to pursue their common goals. This is understandable, and it would be acceptable, if not for the character of one of the main factions to this reconciliation. Make no mistake about it, Mr. President, Hamas is a terrorist organization. This group denies Israel its right to exist. It fires thousands of rockets into Israeli territory and bemoans the death of bin Laden, one of its heroes. If this announced reconciliation of these Palestinian groups actually occurs, the Palestinian Authority of Prime Minister Abbas, to which the United States, by the way, provides considerable financial and humanitarian support, that administration, that group, that reconciliation will have Prime Minister Abbas and that group dancing with the devil. It cannot, therefore, expect further support from us, nor can it expect support or understanding in any negotiations with Israel intending to create a Palestinian state. Indeed, we must not require or even encourage Israel to resume negotiations with an entity that includes terrorists. But how did the President address this in his speech? He did not mention the word terrorist or provide any solid indication that negotiations with Hamas would be impossible. He did not affirm that American assistance to Palestinians, including Hamas, would be off the table. He merely said that, and I quote, Palestinian leaders will have to provide a credible answer to these remaining questions. The President also suggested in his speech that the Israelis and Palestinians should focus negotiations in a restarted peace process on the issue of borders and security, leaving the highly contentious issues of Jerusalem and refugees for later. This type of step-by-step negotiating has been rejected many times in the past, and for good reason. Land is Israel's main asset in negotiations. Even if it were possible to reach agreement on land and borders first, Israel would be left in a far weaker position to negotiate the subsequent matters. The refugee issue is perhaps the most difficult of all, because acceptance of the Palestinian position would completely change the nature of Israel as a Jewish state. Indeed, it is a fundamental survival issue that cannot be addressed in isolation. Finally, Mr. President, I am deeply concerned that the President's speech may be used by the Palestinians to support their campaign to bring a unilateral declaration of statehood from the United Nations General Assembly. A declaration of statehood to the UN is a dangerous step that would preempt any new negotiations and make sure such efforts are stillborn. If this strategy succeeds at the UN General Assembly this September, it will bring serious legal, political, diplomatic, and practical negative consequences for both a real peace process and Israel itself. Mr. President, let me restate that. If this strategy succeeds at the UN General Assembly in September, it will bring serious legal, political, diplomatic, and practical negative consequences for both a real peace process and for Israel itself. The Palestinian Authority has already announced its intentions to challenge Israeli interest in UN-related bodies, including the International Court. This tactic contradicts Palestinian claims that it seeks to bring new energy to the peace process. Peace will come through realistic negotiations, not through unilateral preemptive action. The President did say that he opposes this Palestinian effort to isolate and delegitimize Israel at the UN, and this was a welcome statement. But supporting a Palestinian state based on 1967 borders, speaking out against the alleged reconciliation with the terrorist faction Hamas is in only the most ambiguous terms, and promoting a policy that deprives Israel of its strongest negotiating advantage will only encourage the Palestinian Authority to pursue its UN strategy. These confusing, inconsistent messages from the administration will not be enough to dissuade other UN member states from supporting the Palestinian maneuver. I fear that the United States will then be forced to veto a resolution in the Security Council that our very own errors have helped bring about. Then we will find ourselves in a minority in the General Assembly and watch as the prospect of substantive negotiations become far more distant than before. Both we and our Israeli friends deserve better than this. Mr. President, this is not a statement of support for Israel only. It is true that we are united with Israel by permanent bonds of history, values, shared strategic interests, culture, and religious heritage. But those bonds are also the principal reason we have for pursuing a peace that is durable and just for everyone in the region. That peace will serve the Palestinian people just as much as Jewish Israel. A secure homeland of their own at peace will be the result of real negotiations based on shared understanding of what is possible. Americans, the people of Israel, and the Palestinian people all have a shared common heritage in prophetic religions. Hopefully, prayerfully, together, we can aspire to a common purpose to bring enduring peace to the birthplace of that heritage. Mr. President, I yield the floor.
Mr. President.
Senator from Montana.
Thank you, Mr. President. Today, Mr. President, we have an opportunity